Hello everyone and welcome back in part 3rd of the Bear Act. In earlier two videos, I have discussed each article in details with example from 1 to 18. And in this video, that means part 4th, it is part 4th, okay. So in this video, we will discuss from 19 to 24 with original text and explanation of each clause one by one. So stay tuned with me, and I would recommend you that if you have not watched the previous video, then go first, watch that video, and then come to this video. It will make a sense, right? Because that will cover from article 1 to article 24. So as you all know that there is a fundamental right in part 3rd of the Indian Constitution, and in part 3rd there are originally 7 types of the fundamental right were provided, but according to 44th Constitutional Amendment Act, right to property removed from the fundamental right. Okay, right to property removed from the fundamental right. Now it is a legal or constitutional right under article 300A. Okay, so there are only 6 type of fundamental right that are available to the citizen of India, right? Now from article 19 to article 22, it is about the freedom of expression. From 14 to 18, it was about the right to equality and equal protection of the laws. And from 23 and 24, it is right against the exploitation. Okay, so we are going to discuss two part of the fundamental right. One from 19 to 22, that means freedom of speech and expression, and the other is right against exploitation, that has two article, article 23 and article 24. Okay, so let us now start with article 19. So article 19 is about the protection of certain rights regarding freedom of speech, etc. Okay, etc, whatever. Now the text says that all citizens shall have the right. For what right? So they have a freedom of speech and expression, 19 clause A. They have a right to assemble peaceably and without arms. There should be no arms when you are assembly in a peaceful manner. Okay, and to form associations or union or the cooperative societies. In the previous year, if you have solved the previous year GS1 questions, then you got a question that basically talking about the cooperative societies. So it is mentioned in DPSP as well. Okay, apart from this, it is mentioned in the fundamental right as well. And 97th Constitutional Amendment Act 2023, oh sorry, 2011. Okay, and it was granted constitutional status, and one part was added, and that part was 9th B. Okay, clear now. So DPSP, oh sorry, cooperative societies can be found in different parts of the constitution, and all citizens have also right to freely throughout the territory of India, but doesn't mean that if there is a prohibition to move in the territory of any tribal area. Okay, if there is a prohibition, then you are not allowed to walk freely in that area. Okay, as we have told earlier that if there are a fundamental right except article number 17, all fundamental right have exception. Okay, and I will going to discuss the exception on the basis of which this fundamental right can be curtailed or abridged. Okay, now all citizens have the right to reside and settle in any part of the territory of India. But let me tell you, is territory defined in the constitution or not? Yes, because territory include what? State, you teach, are territories that may be acquired by the government of India in the future, that comprise territory. Okay, so any part of the territory, if you want to reside or to settle, then you can. Okay, and to practice any profession or to carry on any occupation, trade or business. Okay, then you can observe here there are 6 rights that are mentioned in the article 19. Okay, now if I have to explain in a very simplest form, then article gives 6 fundamental freedoms to every Indian citizen, and these freedoms are freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form associations or the unions, freedom to move freely throughout the India, freedom to reside and settle anywhere in India, and freedom to practice any profession, trade or business. So if a question asked by any competitive exam, in any competitive exam, that how many rights are mentioned in article 19. There are 6 rights that are mentioned in article 19. Okay, and you should memorize these rights as well. Okay, but tell me one thing, that does this right or these rights that are mentioned under article 19, are they absolute? No. There is only one article that are absolute in nature, and that is article 17. Okay, so yes, these freedom are not absolute. They can be abridged, they can be curtailed even. Okay, and the state can impose reasonable restriction. But what is reasonable restriction is nowhere defined. Nowhere reasonable restriction is defined, that what comprise actually reasonable restriction. Okay, in the interest of sovereignty and integrity of India, security of state, public order, decency, morality, and other constitutional grounds. Now other constitutional ground does not make it limited, it makes unlimited. Okay, so there can be other grounds as well, on the basis of which this article or these rights can be curtailed or abridged. Okay, and during national emergency, okay, during national emergency, article 19 suspended automatically. Okay, article 19 suspended automatically and even revoked automatically. Okay, so this article is very important one. Okay, now let us suppose that you are free to criticize a government policy. Okay, but you can't use speech to spread violence or threaten national security. Okay, because your rights can be abridged or can be curtailed. These are the grounds that you should keep in mind while enjoying your right. Okay, from the exam point of view, that it is available only to citizen, not to aliens or the foreigner. Okay, contains 6 freedom and subject to reasonable restriction. But what comprise reasonable restriction, I don't know. Okay, now article 20. So article 20 is talking about protection in respect of conviction for offenses. If you are convicted for any offenses, there is a term called acquitted, that all the charges are removed that was against you, and one is conviction, that if charges is proved against you. Okay, so no person shall be convicted for an act which was not an offense when it was committed. Now let us understand this clause with an example. Now suppose at present time there is a law for an offense, that you will be charged with 1 lakh rupees plus 1 year punishment. Okay, these are the punishment at this time. Okay, now you are committed the crime at this time, then the punishment will look like this, that you have to pay 1 lakh rupee plus you have to spend 1 years in jail. Okay, but let's suppose after few years you have committed same crime again, and at that time it become 2 lakh plus 2 years. Okay, then what happen, you will be convicted or you will get punishment according to the present laws. That is the simple meaning. Okay, that means when offense was committed, okay, at that time the law that was prevailing, that was making that offense is crime, only on that way any person can be convicted. Okay, to convict for an act which was not an offense, jo offense nahi tha, okay, when it was committed. Okay, now later it was made an offense. Okay, now let us another example. Okay, now suppose drinking water from a public office, in a public office. Simple, if you are not a public servant and if you have used their water bottle, and that is not a punishment as of now, but after few years what happened, that become a punishment, that become an offense. Basically, if that become an offense and you committed the crime and you committed this act earlier, now just tell me, could you be convicted? No. Why? Because there were no law was exist at that time when you commit that act. Simple meaning. Okay, now to be prosecuted and punished for the same offense more than once, if you committed a crime then you will get punishment. And then again, let's suppose uh, if you have fulfilled certain condition and you are now out of jail, okay, out from the jail, then after few years and the police knock at your door and simply says that no, you just spend 20 years in the jail, but as of now the maximum punishment for this is 22 years, so you have to spend 2 years more. No, because at that time when the offense was committed, there was 20 years imprisonment. Okay, so to be prosecuted and punished for the same offense more than once, no, nor any person can be punished for the same offense more than once. Okay, and to be compelled to be witness against himself. So article 20 included three parts. Okay, no ex post facto law. Okay, no self incrimination 20 clause third, and no double jeopardy. No double jeopardy. Okay, now so article 20 protect people who are accused of crime. They are accused still. Okay, they are accused still and they are not convicted. So it provides three important safeguard who are the accused of the crime. What are these? That ex post facto law, a person cannot be punished for an act that was not an offense when it was committed. Second is double jeopardy. That means a person cannot be punished twice for the same offense. And third is self-incrimination, that no person can be forced to give evidence against themselves. If police is forcing you that when you will go to the court and before magistrate, you have to say that yes, I committed this crime. No, this is not allowed actually, and magistrate will not consider your opinion. Okay, they will not consider it as a valid opinion because no person can be forced to give evidence against themselves. Let us understand this through an example. Now suppose if an act was legal in 2025 but declared illegal in 2026, then a person cannot be punished for doing that act in 2025. If a person has done something in 25, then he can't be punished according to 2026 law. That is the simple meaning. It applies to all persons, whether citizen or foreigner. 3 constitutional protection. 21, that means no ex post facto law. 22, no double jeopardy. And 23, no self incrimination, an important safeguard in criminal laws. Okay, article 21, that means protection of life and civil liberty. Okay, now no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now so article 21 is one of the most important articles in the constitution because it provides citizen a personal liberty. Okay, now it says that no person's life or personal liberty can be taken away except according to the fair and valid legal procedure. Okay, now if parliament make a law and that make certain act as a crime, okay, but actually it is not a legal, it is not a fair. If it is not a fair, then that law can't take your personal liberty. Okay, but if that is fair, then your right can be taken away, your right can be abridged. Over the years, the Supreme Court has interpreted Article 21 very broadly, and it includes many articles as of now, like right to live with dignity, right to privacy, right to clean environment, right to legal aid, right to speedy trial, right to livelihood, and menstrual health also included under the Article 21. Now, a person can't be arrested or imprisoned without the following procedure established by law. From of exam point of view, applies to every person. Widest interpretation among the fundamental right and expanded through judicial interpretation because Supreme Court through the various judgment includes many rights under Article 21. Okay. Now Article 21A, it was added by 86th Constitutional Amendment Act. Okay, and it is about right to education. 21A. Okay, now 21A says that state shall provide free and compulsory education to all children of the age of 6 to 14 years. So is there a mention of the years? Yes, 6 to 14 years. In such manner a state may by law determine. Now let's suppose if there is a child and whose age lies between 6 to 14 years, then that child has a right and fundamental right even that they can demand free and compulsory education because obviously it is their right. Okay, and the government will provide them with zero cost education. Okay, even uniforms, books and bags are provided by the government. So if a child is under this age, comes under this eligibility criteria, then government will provide free of education and compulsory education. Okay, and this article was inserted by 86 Constitutional Amendment Act 2022 during the prime ministership of who was the prime minister at that time. So Atal Bihari Vajpayee was the prime minister when this article 21A was included by 86th Amendment Act. Okay, now the government fulfilled this through the right to education, right to children to fair and compulsory education act 2019. Okay, Now, if a child is aged 10 years and they have a constitutional right to receive free elementary education. From exam point of view, what is age criteria? 6 to 14 years. And it was added through which constitutional amendment act? It is 6th Constitutional Amendment Act 2002, and it is implemented through RTE Act 2019 to make 21A right to education enforceable. Okay. Now, Article 22. Now, Article 22 talking about the protection against arrest. If you are arrested, then what are the rights that are available to you? That is provided by Article 22. And there is a two kind of arrest maybe. One is simple arrest and one under preventive detention laws, right? And obviously they both have a different right, okay, according to the situation. Now, if you are arrested under simple laws because you have committed crime, then you have a certain right, like to hire an advocate, right? To know what are the basic, what are the causes. That's why you get arrested. So these are the rights that are provided when you are arrested under the laws. Okay. So no person who is arrested shall be detained in custody without being informed ground of arrest. That means on what ground you are arrested. Nor shall be denied the right to consult. That means right to hire an advocate and to be defended by a legal practitioner of his choice. Okay. And the third right is that is you have to the police have to present you nearest magistrate within 24 hours of the arrest. Does it include travel time? No. Because let's suppose if police arrested a person from the Assam and they have to bring that person to the Uttar Pradesh, right? Then it is may that police can take, or the travel time can exceed 24 hours, right? So travel time generally not included. So there are three rights that are available when you are arrested under the simple laws. One, you have right to hire a legal practitioner. You have a right to know the grounds on which you are arrested. And the third is that the police will have to present you to the before magistrate within 24 hours of the arrest, excluding the time necessary for the journey. Okay. Now, Article 22 protect the rights of a person who is arrested. Okay. And in my earlier article number 20. Okay. So if you are arrested also, there are certain rights that are available under Article 20, but it is before conviction. No, this right is before conviction and this right is after conviction. Okay. So an arrested person has the right to know the reason for their arrest, to consult a lawyer and to be defended by a lawyer of their choice, and to produce before nearest magistrate within 24 hours. And this article also contain there are some provisions about the preventive detention subject to constitutional safeguard. Okay. Now suppose if police arrest a person, they can't keep them in custody for several days without producing them before a magistrate. That means within 24 hours of the arrest. From the exam point of view, protection against arbitrary arrest included under Article 22. Right to legal counsel under Article 22. Production before magistrate within 24 hours under Article 22 include preventive detention provision. And the maximum is 3 months under the preventive detention unless a board of the judges extend your arrest. Okay. Unless board of the judges of high court extend your detention, then the maximum detention time under any preventive detention laws, there are some exceptions as well, is 3 months. Now Article 23. Now right against exploitation included under Article 23 and under Article 24. Okay. Article 23 is basically talking about prohibition of traffic. Traffic means sale of the girls or the child or the boys, okay, in human beings in forced labor. That means you are not going to pay anything for the work that someone has done to you. That is main, you can call it forced labor. That means begar. So these are the some nuance that are prohibited. These are the nuance, right, that are prohibited under Article 23. So prohibition of traffic of human being and forced labor. Now, traffic in human being in begar and some other similar form of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with the law, and accordingly Parliament ultimately created or make the law to make it punishable offence. So Article 23 protect people from the exploitation. It prohibits human trafficking, begar, that means work without payment, forced labor and any similar form of exploitation. And one more important feature of this article is that this article applies against both state as well as private individual. Okay, so here in this article, private individual also comes under definition of the state. Now, making a laborer work without wages, again their bill is unconstitutional. From exam point of view, this prohibits trafficking and forced labor. This covers both government and private person. In violation is punishable by the law, and that law made by the parliament. Now, Article 24, prohibition of employment of children in factories, etc. But they can work non-hazardous activity, or they can be engaged in non-hazardous activity in their homes. Okay. Now, no child below the age of 14 years shall be employed to work in any factory or mine or engaged in other hazardous employment. Okay, so Article 24 protects children from the hazardous work. Okay, from the hazardous work, not non-hazardous work. If a child is below 14 years of age, they can't be employed in factories, mines, or any hazardous occupation. What are the objectives of these articles that are provided? A right against exploitation, that means article 22, its objective is to protect children, right, and their education and overall their development. Okay, because suppose there are children that are working day night, they do not get time to study, right, and they will not get the time to express themselves, to develop scientific temper, to develop scientific mind. Okay, so if you think that it is against their right, so it provides children overall development, whether it was about the mental development or anyone. Okay, now a factory, let's suppose, employing a 12-year-old child, that violates article 24. From exam point of view, applies to children below 14 years. Factory, mines, and hazardous employment are prohibited and protect children's welfare and education. So let us take a quick revision that what we are read. Article 19 contains 6 fundamental rights, that is freedom, and article 19 to 22. Article 20 contains 3 parts. That first part is no ex post facto law, second part is no double jeopardy, and third part is no self incrimination. Article 21, right to life and personal liberty. Article 21A, right to education. Article 22, protection against arrest and detention. And Article 23, human trafficking and forced labor prohibited. And Article 24, child labor in hazardous activity. That is it for today. And let me know how the video is basically. And if you like this initiative, let me know in comment section. Subscribe also, like the video, and share your thought in comment section as well. Okay.